I think one of the things that's really changed is that people, since we don't try cases as much as we used to have a lot of camaraderie with the other side, and we'd be able to sit down and talk cases and settle them together. We don't do that anymore. And because so many lawyers are inexperienced, it's led to this whole civility problem that we have. That I like Kubota because you can still talk to old time trial lawyers, but these younger lawyers, they're fighting over discovery all the time. And there's a nastiness that kind of comes about it because they're uncertain of themselves. If you're cut out of the cloth that I was and my predecessors were, where you tried cases all the time and it became normal. You try a case, you win some, you lose some. You could kind of roll with the punches. But now a trial becomes something of a huge, big problem because you don't try very many cases. People are paying attention to it. And so the stress of trying a case becomes something very different than it was when I could just pick up a file and go down and try a case.
Howdy, and welcome to the show. Cooper's Code focuses on legal issues and notable practitioners, distilling wisdom so we all achieve the best results for our clients. I'm Miles Cooper, and I'm thrilled to share this conversation with the legendary Gary Gwilliam. I love talking about what I would describe as kind of early civil practice with trial lawyers of your era, because for those of us who spend a lot more of our time doing depositions and mediations than trial work now, hearing about life in the era of here's a file, go try it.
Yeah, right.
Is kind of exciting to hear about. So can you talk a little bit about what that was like?
Yeah, I can. My former partner, Ed DeGardi, tried cases in the 50s, and he tried 29 jury trials, plaintiff's personal injury jury trials in 1 year, because they didn't have settlement conferences. What happened in those days, and this is the 40s and the 50s and maybe the early 60s, is that the insurance defense attorney and us would file a lawsuit. They'd answer, but they'd maybe take one deposition, and then we'd set a trial, and we'd walk into the trial, and they'd put on the plaintiff because they didn't take depositions. They put the plaintiff on direct examination. They'd break for lunch. They'd go out and have lunch, and they'd come back and settle the case. So you started trials as a part of settlement. When I started trying cases, this was you took cases and you tried them. And you'd go to a trial judge and he'd say, hey, guys, and they were all guys, I think we can talk about settlement. No, I don't think so. We're ready to try the case. So we'd try the case. I was trying like 10 trials in a year. And then in the end of the 70s, at the end of the 60s, early or about maybe 1970, in Alameda County, we decided to do something entirely different. We decided to start talking about when we could settle cases. And so we took two judges, Deedon and LaCara, and we said, we're going to treat them as settlement conference judges and do something we've never done before. We're going to start talking settlement 2 weeks before trial. And so suddenly things began to change. And that's when we began to think about, maybe we were seeing more cases come, but we began to think more settlement than trial. And that dramatically changed everything. And then in about 1980, we moved to begin talking about, maybe there should be some retired judges who can help us. Let's try something called mediation. All brand new, mediation, maybe 1980s and stuff. And then we began mediating trials. And then I wrote an article for the Kubota Journal in 1999. And in that, I wrote, "Are trial lawyers becoming extinct?" Because I became concerned that we weren't really trying cases anymore. And that all we were doing was taking depositions and doing mediations. And at that time, it bothered me. And I wasn't sure that was the way to go because I was so ingrained in being a trial lawyer. I've tried 180 jury trials to verdict, most of those earlier in my career. But now I've changed my feelings about that. And I think that the win-win philosophy is probably a better way to go. And I don't think we need to try as many cases as we used to. I think somebody can try way more cases and still have an experience. And we're trying cases differently. We're trying cases much more with the technology and using a lot of demonstrative evidence that Melvin Belli kind of started as this. So I've seen it change dramatically over my long career. And it's very interesting, and it's still developing to a certain extent. But it's very interesting to see how life has changed for old trial lawyers like me.
Anything in particular that stands out for you as a, wow, this is great, and I'm so glad that I have this in my arsenal at this point in my career versus things that you didn't have, say, back in the 70s, 80s?
I think the whole way we can put on depositions in trial and use a lot of the technology is great, and I think that it's good. I think the main thing, that one of the things, is the use of really good jury consultants, and I don't think if your case is serious enough to go to trial and it involves some money, even after all the cases I've tried, I very much need a trial consultant. And I think the use of a good trial consultant, even for purposes of evaluating your case for settlement, is really worthwhile. And I think a lot of that has changed. And so I think we understand the dynamics of trials better. I think we understand juries a lot better than we used to. And it's interesting. There's been a lot of changes that have come about with our ability to communicate better. And, courses that we take as trial lawyers now are very different than they were when I was a young lawyer. So all I can say is it's really been interesting for me to see this change over such a long period of trying cases. Very interesting to me to be able to be an observer in that and still be pretty compass mentis, if I do say so myself.
I'd ask a similar question on the settlement front. There's a reason I'm bringing this up. I've brought it up, I think, with some others. It used to be that trial lawyers would be able to go out to lunch, talk about a case, and be able to wrap it. And I think mediation is a wonderful tool that has come along and helped resolve a lot of cases. What I'm noticing for myself in particular, and younger lawyers, is some of us either never developed that skill or have lost that skill in terms of being able to resolve cases informally. Do you have any observations from within?
No, I think one of the things that's really changed is that people, since we don't try cases as much as we used to have a lot of camaraderie with the other side, and we'd be able to sit down and talk cases and settle them together. We don't do that anymore. And because so many lawyers are inexperienced, it's led to this whole civility problem that we have. I like Kubota because you can still talk to old-time trial lawyers, but these younger lawyers, they're fighting over discovery all the time. And there's a nastiness that kind of comes about it because they're uncertain of themselves. If you're cut out of the cloth that I was and my predecessors were, where you tried cases all the time and it became normal. You try a case, you win some, you lose some. You could kind of roll with the punches. But now a trial becomes something of a huge, big problem because you don't try very many cases. People are paying attention to it. And so the stress of trying a case becomes something very different than it was when I could just pick up a file and go down and try a case. There was a guy, an old-time defense attorney in Oakland called Woody Kitchell. And Woody Kitchell tried case after case after case. He tried 400 jury trials in his career. I'm at least that many. And he was a very amiable guy, very friendly, very nice guy. But he was a tough cookie in the trial department. But you could get along with him. You could talk to him. You go out and have lunch with people. That I think has changed a little bit with the fact that we don't try as many cases. And therefore, each case becomes kind of a cause célèbre and becomes something to really fear. I mean, because you have this fear of losing, and the fear of losing is a real thing. And I've talked about losses, and I've lost more jury trials than most people in trial. I've lost well over 30 jury trials in my career. I've got a pretty good record, but because I wasn't afraid to try a case. Maybe in retrospect, I've looked back on it, but you just kind of rolled with it, and that's very different than where it is now.
Pivoting into setting up what is now your firm, it was originally you and Eric Ivory, correct?
Right. We started the firm, in 1978.
And I want to bring this up just because I like this story. I know that early on, finances were a little tight, and anything happens, say, in Union Square in terms of walking around and being asked to spell out Rolaids and get some supplemental financing for the firm.
Well, it wasn't so much. It was my money, as it turns out. But it's an interesting story. So in about 1980, we used to, the group of us would go over to San Francisco and we would buy gifts for our wives or others if we wanted to do something like that. So we used to take a time over there and we'd have a nice lunch where we'd have a couple of drinks. Then we'd go over to Magnan's or these other places. And so there was a group of us there. So I'm standing on the street corner one day and one of the guys I'm with says, hey, there's a guy that wants to talk to you about Rolaids. And I said, okay. So this guy comes up, he's got a little thing. He says, do you use Rolaids? And I said, yeah, matter of fact, I do. I try cases and, it's in my gut. And he says, well, how do you spell Rolaids? I said, Rolaids. There's a lot of advertising on the radio and particularly TV. And he says, okay. He says, would you be interested in maybe being on a Rolaids commercial? I said, yeah, why not? So we were at the corner of Union Square. So he said, we walked over a block. We sat down there and there was a camera all set up and there was a guy there that I look at. He says, geez, that's Roger Staubach. I know this guy. Hey, I was a big Raiders fan and he was the quarterback of the Dallas Cowboys at the time. So he's up there with these people that are trying to sell Rolaids and most of them were nervous as hell. They didn't go anywhere. And so I wait for a while, and finally they go me down there, and so I talked to him, and I said, I'm Raiders, and we're just talking football a little bit. I'm a very nice guy, and so I'd had a couple of drinks. I was real loose. Rolaids. Well, let's try that again. Then they have me write it down, and the next thing I'm down there for maybe a half hour, 40 minutes, and so we go through these things, and so when we're done, we walk back up, and it was the Bates Advertising Group, and I said to him, he says, if we're going to give this, we've got to use something called consideration. Do you know what consideration is? I said, well, I've been a lawyer for 20 years. I think I do understand consideration. Well, I'll give you consideration. He says, well, I'll give you $10. I said, well, my usual hourly fee is $2.50 an hour, but I'll take the 10. And so I said to this guy, I said, is there any really chance that I'm going to be on a Rolaids commercial? Probably 1 in 100. We got these all over the country and take it, but we'll let you know. And I said, okay. So I go back and tell the story to other people in my life who kind of laughed about it and I forget about it. And then about 5 or 6 weeks later, I get a big envelope in the mail and it's an application to the Screen Actors Guild. So I had to join the union in order to be in. So then I knew I was going to get something. And then a couple of weeks later, we get a check in the mail. My wife says, oh my God, where'd this come from? It was like $200. And then we started getting these checks every other day. Pretty soon my wife's out there waiting every day. Well, they weren't showing the ads very much in California, but my mom, who was alive at that time in Utah, called me. I think it was in the middle of the night. She says, Gary, I saw you on TV in a Rolaids commercial. And oh my God, she was as proud of me as when I graduated from Citrus Junior College. So I had a lot of friends that laughed about it. So I ended up with about $15,000, which at the time but it was my money. It was not the firm money.
Understood.
It came in handy, but it was a funny story that I've told. And you can still go on YouTube and see me with all my black hair on this Rolaids commercial. It's still out there.
We asked Roger Staubach to find out how people spell relief.
How do you spell relief? For acid indigestion, Rolaids.
I think of Robert Ludlum having made a significant amount of money for, and I can't remember what it was. It was some sort of toilet flusher.
Yeah.
But that's what allowed him to have the money to be able to launch his writing career.
I think they never paid me anywhere near what I should have gotten under the union. But there was no way to track it. I mean, for me, it was kind of pennies from heaven. So what the heck, I had more fun with the story than the money.
I'd like to talk a little bit about your practice and its growth, and I'll lay some foundation for an area that I'd like to go with it. A lot of plaintiffs' firms have lots of trial lawyers. Lots of trial lawyers have egos, and sometimes it can be challenging to keep those people together under the same roof without getting into big fights and people going different ways. One of the things that seems, I won't call it unique because there are firms who do very well. Your firm has really grown and seems to have stayed very solid in terms of its partnership. And I think a learning for people who are in partnerships or thinking of getting into partnerships that would be really useful are some things that you think that you have done well, your firm has done well to be able to foster that.
Well, I think one of the things that now all my original partners are gone, so I've got a different group with me now. But one of the things that I made a choice of early on was that although I had more experience and knew that I would bring in more money to the firm for a lot of different ways, I felt that if I was going to build a firm that I wanted to build and have the kind of firm that I envisioned, that I wanted to not only have my partners feel like they were earning as much as I was, but that we could really enjoy each other and not have to worry about who's going to get the money. So from the very beginning, I never took out any more money than my partners. We kept it even though theoretically I could have gotten more. But I also, because of that, and maybe because of the fact that by the time I'd really gotten into the firm, I'd quit drinking, and we almost never had any arguments or anything about money because we were splitting it all equally. And so it's been kind of that way all along. And because of that, because I've seen some of the prima donna lawyers that have taken the big chunk, and then they've got other people that want to leave and don't think that they're getting enough money. So I fashioned my firm with the idea that we haven't made as much money as a lot of other firms. And I have not made anywhere near as much money as some of my contemporaries that I'm as good a lawyer as they are. But I don't care. I made enough I've never really wanted for anything I didn't want, but I've had more fun. I've enjoyed myself, and to me it was important every single day that you go to work in a place where you're having fun, you enjoy each other, you're not fighting with each other. And I think part of that is that everybody is splitting the money equally. That was part of what I did. But I think also we worked hard, we played hard, and I've just enjoyed, maybe my personality is such, I just enjoy practicing law every single day.
One of the other roles that you've had in your career is being involved in leadership in the trial lawyers organizations.
Right.
And I think it's important for our listeners, a lot of whom were not practicing, may not even have been out of high school at the time that some of these initiative battles happened in the 80s. I'd love to hear a little bit about the 86, 87, 88 battles and the threat that they posed to our profession and consumers overall, and your role in that.
When I was in the trial lawyers, and I became active in the trial lawyers in the 70s when I was president of our local trial lawyers association, was on the board. And we were dealing with no-fault issues, and that was always a big issue, and fighting with the insurance companies. But it was always in the legislature. And all of that changed in 86 when all of a sudden they came out with this initiative, and we were not prepared for it. We'd never dealt with an initiative before. Willie Brown told us that we could get somebody who could take care of us, and I was just Peter Hinton was president of the trial lawyers at that time, good friend of mine from Oakland, and I was the PAC chair, and we raised $5 million, but just got our clock cleaned. And interestingly enough, that came to me about the same time I just quit drinking. I quit drinking in 84, but I relapsed a little bit in 86. So by the time Prop 51 passed in 86, I vowed that I was going to do everything I could to make sure this never happened to us again.
You just answered the question that I was going to pose. 86 was Prop 51, was the modification to joint and several liability.
Well, then I'll put it in context of my career because it was important to me in this. So what happened is I had been president of the local trial lawyers association, and, not really well known other than just kind of locally. But we foresaw that we were going to have more problems with the initiatives, and there was a lot of rumors about what was going on. So the next president was Brown Green. We were moving from north to south, so he was south, and there was a threat then that there was going to be more initiatives. And so what happened is, in the meantime, there was some concern about who was going to be president of the organization. There was a guy, I won't mention his name, but he was from Sacramento that was considered not a strong president. He wasn't well known, well thought of. And so the Southern California people particularly were concerned about getting up somebody. Brown got to know me, and so he kind of promoted me and said, let's get Gary to run for contested election. So they brought me in, but I came in as a parliamentarian, and then moved forward to be president because they needed me to be president in '88. What happens was the initiatives and everything that happened when the Northern California president was there, because the odd years were Southern California, the even years were Northern California. So when '88 came, and I was finally sworn into president, I won't go into the details of how that happened, but we all of a sudden, what hit the wall, and there were 5 initiatives that were filed, including a no-fault initiative. Ralph Nader became involved in Prop 103 and consumer issues. But the one that was existential for the trial lawyers is that the insurance companies had put on Prop 104, which would have capped our fees at 10%. And we were dead if that initiative passed. And incidentally, in the meantime, our California Supreme Court had dramatically changed. They'd kicked off Rosebird. The Rosebird court was gone. So now we had a conservative court that we knew probably would uphold this initiative. So if this initiative passed, we're going to dead. So I came into it, and I knew that I needed to deal with some leadership issues because there was so much fear and tension in our organization. And there was a lot of very wealthy advertising lawyers that had big mills, and the traditional lawyers like Brown Green and a lot of people like I won't say I was quite as hostile to them, but in Southern California, the traditional trial lawyers were very hostile to the lawyers. They didn't try cases. They were not the same. They were marketing people, and so there was a lot of tension between them. But we needed to have everybody come together when we got on this. When we first got in and we had our consultant, the 104 was polling at about 90%, 85 to 90%.
90% in favor.
Cap attorney's fees. Good. That sounds great. Get rid of the goddamn lawyers. And, people were, and so how are we going to beat this thing? So we'd hired the firm that had been against us in 86 that came around to help us. And so we got a game plan as to how we could change it and how we could do some things with it. So we need to raise some money. Well, ultimately, we raised $15 million, which was unheard of at the time. In the meantime, the insurance companies raised $170 million.
Wow.
They spent more money in '88 on these initiatives than they did in the entire presidential campaign. This was Dukakis versus Bush, which shocked us that Dukakis was supposed to win. But so we had this huge amount of money thrown at us, but we had to be smart about it. So when we began to have my board meetings, everybody was interested in what was going on. So the advertising lawyers would come and the other lawyers would love, and they'd come into a big room because it was like a convention meeting at the board meetings. There'd be 100 people, 150 people. Well, the advertising lawyers would be on one side and the other side would be here, and they were just staring at each other, and I'm in the middle trying to make this thing go. So I had to study leadership. So I studied a book called The Tao, T-A-O, The Tao of Leadership, which talked about how you just kind of got to go through it and listen to people. And every time they'd come up and somebody wanted to say, let's pass this, and they say no, and we come to it, I had to find a way not to bring that to a head, because the minute you said somebody's going to win or lose, we're going down the wrong path. We had to stay on a win-win. So I kept kicking the can down the road, and through a lot of maneuvers, I kind of kept them there because we did have the same goal. And ultimately, we convinced all of the advertising lawyers to go completely off the air for the last couple of months of the campaign because they were hurting us by all these horrible lawyers' advertisement things they had. So we didn't know what was going to happen, but I was down at the Biltmore Hotel when the results came in, and we knew we had a shot at it, but we weren't sure. And I had a lot of people that threw a lot of rocks at me, and were, felt that I had not done right. Maybe they wanted to get it, that my president-elect Harvey Levine was angry at me. He thought that we had a better trial consultant. There was like everybody had an idea of how to do this. And so I was kind of in the middle of this thing. And so we were not sure what was going to happen. At the beginning, it looked like we were going to lose. And then slowly it came back up. And finally, we won the thing. And, it was a life-changing experience for me, because I then had gone from just, another Oakland lawyer to somebody that, I think people saw me as a leader, and I saw myself as a leader, and it was a very life-changing experience, and something I'll never forget. It was really quite remarkable, because by then I quit drinking. I was on the spiritual path. I was a different person. I wasn't, I was able to deal with this in a way that I never could have if I was still drinking. I know I couldn't have done it. But it was a lot of fun. And I don't want to say it was me. I mean, I had a really good team of people in Brown and all of the Rick Simmons and Dave Casey and all these people are old friends of mine that were that helped me move through all of this. We had a good core of leadership that helped us with this, Larry Devon and people like that.
That brings me to a modern era question in terms of your thoughts. My understanding is that in Nevada, the rideshare companies are currently funding, it has not made it onto the ballot, but another initiative attempt to cap fees at 20%.
I hadn't heard that.
And I will confess that when I drive through Los Angeles, when I've been to Las Vegas, and it's crept up here as well, some of the billboard advertising is getting so invasive that I worry about a crisis moment, in essence, that consumers who are unaware that they're creating their own doom by passing an initiative like this, may see those ads and get repulsed in a way where we in our profession may be faced with a crisis.
I don't know what they're going to be able to do in Nevada. I know that it was we really had to sit down and talk to people. And there was a guy named Larry Parker. I don't know if you ever heard Larry Parker. Larry Parker was
there's still ads, even though he's not around.
Larry was somebody that I needed to talk to personally about this. He was a big one, and he finally understood it. And I brought him in and talked to our consultant, and he helped us move towards the other ones and talk to the advertising lawyers to get them to, because I think ultimately it made sense that they were going to create their own loss by not paying attention to this advertising stuff. Whether they'll do that in Nevada, I don't know. I hadn't heard that had come about, but then I'm not as active in the trial lawyers as I used to. I'm very connected to the past presidents, but I just haven't been involved in the organization by choice. I've really had to work on my firm with this pandemic, and the whole stuff we've had with the COVID has kind of zeroed me in on just practicing law in the last several years. So I haven't been able to get as active as I'd like to in the trial lawyers again.
If you're enjoying what we're doing here with Cooper's Code, please help us extend our reach by giving us a 5-star review on Apple Podcasts, and consider sharing an episode with a friend. Additionally, we want to know who you want to hear on the show. Have an interview suggestion? Email us at podcast@coopers.law. Well, that's a great segue into talking about how your firm dealt with the idea of COVID, remote work, remote trials. And I know that's kind of a large launch pad from which to speak, but I would love to hear a little bit about some of the work that you have had to put in over the last few years as far as that's concerned.
Well, when the COVID started, first of all, in January of 20, keep in mind this was a couple of months before, it was in March of 20 when the COVID was finally fully recognized. I got the sickest that I think I'd ever been my whole life, and everybody in our firm got it. Well, that turned out I had COVID-19. I didn't know it at the time. But when all of a sudden they said you got to shut down on March 16th, I think it was in 20. Look, I'm a hard copy guy. I don't work, and if I work at home, I've got my computer just set on our kitchen table, and I don't work from home very well. So I said, everybody's supposed to work from home, but there's an exception. If you are an essential service, then you don't have to work from home. So I declared myself an essential service and self-declared that. And I said, F this, I'm going to the office. So if you want to join me, that's fine. Well, people didn't so much, and I didn't try and force him to. But over a period of time, I think our firm came back to practicing more like we did, in part because we like talking to each other. We like going down the hall. We like exchanging ideas with a small firm like ours, where we could sit down and enjoy each other's company, but talk about it. So the partners came back relatively soon, and some of the staff did too. So I'd say by the end of 20, we were operating more almost entirely in the office. But if people wanted to do from home, we were not. They had a right to do that. In that sense, we survived the pandemic very well. In the sense, like so many other firms, it really caused us problems because we couldn't try our cases for 2 years. And I think we're still kind of catching up with that, and with finding that the courts are still jammed up and cases are getting kicked 2 years down the line. And, justice delayed is justice denied for plaintiffs' firms, I don't need to tell you. But so so I needed to just kind of grind out and really work hard to try and keep the firm going. And that's what I've been doing for the last 4 years.
Any experience with remote trials and thoughts of how that impacts juror deliberations?
Look, I had a trial last year that was the biggest firm. We put all a lot of eggs in one basket. I ended up, because I did a lot of employment work as well as the traditional PI work, we ended up representing about 75 longtime farmers insurance agents who had been fired because and all of them had worked there for a long time. And they were allegedly independent agents, but they were being treated like employers. And so we had the farmers company did something that none of these other companies had done. And so as far as I was concerned, we had a hell of a good case. We got into this case, and it became even better when we were able to, first they said, well, you can't take the CEO's deposition under this Apex rule. You can't go up there. But we had all kinds of information that the program that they were using to terminate all these agents was happening at the very top of the company. And finally, the judge ordered that we could take the deposition of the CEO. When we did, we got his emails. And in one of his emails, he said he wanted to get rid of 3,000 shit agents. And he put that in writing.
Wow.
On an email of exactly that. So we had this guy, and he didn't make a good impression. So we tried to get the case settled, and we couldn't. So we went to trial, and I thought the trial went in well, but it was a remote trial. Well, let me say this. It was the first trial that had been tried in the complex litigation department with Judge Siegelman, good judge, Seligman. So we were in a relatively small courtroom, as they are over in Alameda County. And so we agreed that we're going to try this case in person. So we picked our jury. We started the trial. We put on a couple of witnesses, but there was still a lot of the COVID going on. So we only went a couple of days. And then the following Monday when we came in, a couple of our jurors had COVID, and there was a lot of problems there. So the judge says, I'm going remote on this. Well, we were so far into this case that I wanted to move forward with it. So I wasn't, and I talked to some people and had some okay experiences with remote jurors, although, as it turns out, not to be as complex as this case was. So this case then had the juries not come into the courtroom. So they'd barely gotten started in this case when all of a sudden we had, I think, 18 starting. We had a lot of alternates. but we only had two screens in the room. So one was on the witness and one was on the document. So when we had a witness and a document on, you could see the jury when there wasn't a document on. But other than that, you couldn't see the jury. And when we saw the jury, you could see them in the distance, and some of them were, and one of the defense attorneys complained that somebody was vaping. People were sitting there in like their bathrobes watching this thing.
Just to help paint the picture, is my understanding clear that the lawyers and the witness and the judge were in the department, but the jurors were the remotes? Right. They were home.
Everything was there.
Okay.
So we called the witness to the witness stand. We pulled the document up. Everybody was there. It was a jammed courtroom. Some of our clients were there. And the judge did not let us allow all of our clients to testify. There were some things that happened that I think were a problem for us as it went on. But I thought the case went in well. And I thought we were going to win it. And I think the defense thought we were going to win it too. But the problem happened, Miles, and I think I'm going to write an article about this case when it's done. We're still mediating the case, so I'm not ready to go public on it yet. But I think trial lawyers need to be aware of this, because what happened is when we finally got to argue the case, the judge said, all right, I'm going to have the jury come back in for argument. By then, and incidentally, there had been a week delay. There had been a lot of delays in the case that had dragged it out, which is not good for plaintiffs. So we had the jury come in and we argued the case, and then they went out and deliberated. But the first question they had to ask, I had 4 plaintiffs that were kind of test plaintiffs in this case of the 75. But we had 20 questions for each juror. It was a complicated verdict form. And so there was a lot of work that this jury needed to do if they were going to do their job. But I think that when they went into this thing, they looked at this and said, the easy way out is just to answer the first question. Are you independent contractors? Yes. Now, we even had the burden of proof that they were employers. So we should have won that. We had 2 dissenting jurors, but I am quite convinced that what they did was a cop-out. They didn't know each other. They didn't like each other. They didn't want to, there was no camaraderie. And in order to have a jury work the way it should, like you see even in the Trump cases and the rest of them, these juries get to know each other. They form friendships. They form groups. And to me, we had 12 independent people that didn't know or care for each other. And so the jury foreman, a couple of them just said, now the hell with it. Let's just let it go. And so they ruled against us. But I think that's the dangers of a remote trial that really concern me.
The word that Cynthia McGuinn and I used to use when we'd see the coalescence happen was jurify. Yeah. Where they went from being individuals to hanging out, going out to lunch together.
You need that.
Yeah.
Yeah. And I'm telling you, I don't think I certainly didn't understand how serious it was in this case until I realized, and I talked to the Senate jurors and saw how quickly they did this, and they had their verdict within a day, and then they got lunch so that they get a free lunch and went home. But so the case is on appeal, and we're still trying to get the case settled. So there's still hope for the case, but it was a really disappointing experience because I didn't try it myself, but I did a lot of the heavy lifting. I cross-examined the CEO and did some other work, and I felt really good. Interestingly enough, I mean, I was trying a case at 85 years old, got COVID in the middle of it. I said, what the hell? Maybe I'm still a trial lawyer, which I think I am. But it was a difficult experience, and it was kind of testing,
If I were to get a takeaway from this, in these odd hybrid trials, if somebody's going to be remote, the lawyers be remote and have the jury at least have the opportunity to interact on a more daily basis.
No, I'm not sure about remote trials anymore after this experience. I just think we have to be careful. I think if you had a short trial and an easy trial where the jury didn't have that problem so much, but on a long trial with a lot of complicated issues where the jury needs to spend a lot of time on this, they were not motivated to sit down and try and do the job they're supposed to do. So I would say I would be very concerned about trying a complex case, a long case, where the jury's remote. Maybe we're moving towards more remote trials, but I am going to try and write an article maybe for the Abota Journal or whoever will publish it, the American Trial Lawyers or whoever, but about this case at the right time, because I think it's something we need to be very concerned about. It's a danger point that I think so many people aren't trying cases anymore. They think, well, it's just a remote trial, will be fine. But that was my experience anyway.
In general, not specific to this case, do you use focus groups as you're preparing for these types of cases?
Yeah, I've got the best focus group that I've had for focus group for a long time. Karen Jo Coonan was one of it. She died not too long ago. But no, even with all my experience, I still think you need focus groups. I think it's just very helpful to kind of get a sense, not only, and sometimes just for settlement. I mean, on a big case, you need to know how good your case really is. We had a case recently that we had a lot of trouble with in terms of getting settled, but the focus group didn't go well for us on a case that should have been a good case. But the jury just didn't like the people, and you had that worry. So there's some intangibles. We learn, we get so that we like our clients, and we kind of, I think no matter how objective we try to be about how they're going to do in trial, I think sometimes we kid ourselves that clients are not going to come across as well, or the themes we think we're going to win aren't. And even with all my experience, I still feel much more comfortable in having a focus group to, for a lot of reasons. Sometimes to help me pick the jury, but certainly to work on the themes and decide where we need to go in terms of how we emphasize and how we really try our case.
You mentioned trying this case when you were 85. I think you said you're 87 now.
Right.
You don't seem like you're slowing down at all. And in the public eye right now is President Biden, who decided to withdraw because he was having some challenges at 81.
Right.
How have you been able to keep going in a way where there are a lot of your contemporaries who have not?
Well, a couple of reasons. First of all, I've been very lucky with my health, even though I've had little traumas recently. I started practicing law in Oakland on May 1st, 1966. If you took every single day that I've missed from work, even with my recent times, it might be as much as 2 to 3 weeks. So I've been very healthy. I took a lot of vitamins. I'm a vitamin C guy. So I've had I haven't had my health deteriorate. I've got a knee that needs some help in the sun. So I've been healthy even through all my drinking and my smoking. That's one thing. But more importantly, I really think that age is a state of mind. We talked about this a little bit. I told you that I really believe that 80 is the new 60 for me. And when I first of all, I got married on my 60th birthday for my third marriage, which I think was a really smart move, because I'm not going to F up my anniversaries. I got this one down pat, so I'm not going to mess this up with my other anniversaries. But I felt really good then at 60. When I turned 70, somebody said 70 is the new 50. I felt that I wasn't anywhere near. And then when I hit 80, 80 is the new 60. I really think of myself, Miles, as being older. I really do think that this is a mind-body medicine thing. I think if you really think of yourself as being healthy and good, you are. But if you start saying, oh my God, I feel bad, I'm breaking down, and then you are. And so I think people don't understand how you can do this. I listen to music out of my 50s and 60s. I still think of myself as a young guy. I've also taken care of myself so that I look better. I've done a little Botox. I've done a little work to keep my skin going. So, if you look better, I don't think I look my age. I hope I don't. I don't want to look my age, so I don't want to act my age. So I don't know how long I'll be able to keep this up, because most of my contemporaries are not there, aren't able to do it. But I know my partners will keep an eye on me and make sure. So when I reach the stage when I'm drooling on my desk, they're carrying me out of there. But until then, there's no R word in my vocabulary. The retirement word is off my vocabulary.
At some point, there may be somebody who is your Nancy Pelosi, but you will keep on going until you're told not to.
I don't know. I mean, I think you phase out. I wouldn't try a case by myself anymore. This case I tried had 3 lawyers on it. So I'm doing different things that I've done over the years to be more of a mentor and do more strategy stuff than the hard work anymore. So, but that's fine too. So I'm very happy with the way my career is still going. For me, it works. It's not for everybody, but it works well for me.
As we come into the home stretch, Gary, is there anything else that you think it's important for our listeners to know?
Well, I'd like to talk a little bit about the fact that I have was one of the first lawyers to ever write about how we deal with our losses. In all my career, I've been to every seminar you can imagine, and it's always about win-win and how you win, how this. And yet, I've talked to so many lawyers that have been devastated by losses, and we're not supposed to lose, and you become isolated when you lose. I've seen people that have lost their whole careers over the loss of a case. So after I had tried a number of cases, and I had a very difficult case that I tried about the same time that I was the president of the Trial Lawyers Association. It didn't go well, and in the middle of my case, my mother died. And so when I came back, it was a med-mal case, and I lost the case. And I came back into my office, and on that, I was working Saturdays, and I came in Saturday, and I sat down, and I was thinking about this whole thing with my mother and losing this case and what it meant. And I was in a different place, and I quit drinking. I was kind of on the spiritual journey, and I said, I'm going to write down the things that are is there anything good about losing or are they? So I took a yellow pad and put a line down the sign. On the bad side, I said, losing, you don't get any money. So that's one of the things. On the other hand, I said, I tried this case with my partner. It was a new partner, and he and I really got to know each other. My clients appreciated what I did and what I did. The defense attorney was a damn good guy, and I felt that I'd learned something from him. So I started writing down all these reasons why there were good things about losing. And I said, I'm going to turn this into an article. So I wrote an article in the late 90s called The Art of Losing. And I got a lot of really good feedback on it. And I've followed up with it with another article called Lessons from Losing. And there's a whole bunch of things that that are important about losing. One of it is that we have compassion for others. One of it is that we have more experience, we lose from experience. And there's a whole bunch of issues that we can take from losing, and people remember their losses. And so I think, there's courage. There's a courage to stand up and go again. There's a whole bunch of things that forge us out of losing. And having the kind of career I did where I lost so many cases earlier, it didn't hit me as hard as others, but I've had a tremendous feedback. And part of my book is about this, on the fact that I've been able to discuss that it's okay to lose a case and that there's good things about losses. And that's never a message that has been very well received by lawyers. It's win, win, win. And I think it's still out there, but there are good things about losses that it's no fun, but sometimes the best things that we lose are our most difficult lessons,
As one reads a good portion of your book, that's a little bit of the theme that it is built around. It's a reflection on a loss that guides the storyline for quite a bit.
Yeah, it's not just losing cases. It's losing relationships. It's losing people that die. It's losing my mother. There's a lot of things, and I've learned more about grieving, and I've read very interesting books about grieving and things we can do. So I think we need to be aware of this, and sometimes we kind of shut down on it. But it's not just losing cases. It's that they have a lot of losses, and we learn from our losses. And I've had such a tremendous amount of different losses in my life that I think it's forged me and made me strong to the point where I'm still functioning pretty well at this late stage of my life. I think that's part of it.
I really appreciate you taking the time and coming, Gary.
I very much appreciate your putting me on this podcast. It's not something that I've done much recently, and I very much appreciate the opportunity to be on it. So thank you very much for having me.
For anyone who is interested, Gary's book is available on Amazon, and there is an audiobook as well.
Anybody who wants the book can also contact me directly. I have extra copies that I'd be glad to give to somebody. I didn't make any money on the book, but if somebody's interested, I'll be more than glad to give them a copy.
Well, there you have it. You can get it directly from Gary.
Thanks.
And thank you for listening today. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions for who we should have on the show. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.